This is Erica Merrill, and I'm the founder of Perfect Legal Video. And I am very excited to have with us today attorney Robert Howard. And he's an attorney over at the Stewart Law Group in Phoenix, Arizona. They are a family law firm. And today's topic is one that I'm sure a lot of people wish they had learned more about before they got married, and that is prenups. I want to welcome you to the first time on the show today. Thank you so much for joining us, Robert.
I'm happy to be here.
Perfect. So let's talk about first defining a prenup. I mean, for those people think they know, but I'm sure that there are a lot of misunderstandings about what it is exactly. So if you could just define it for us, we can get into the nitty-gritty after.
Sure. A prenuptial agreement is an agreement signed prior to marriage, which generally changes the normal community property laws that apply in the state of Arizona. We may make significant changes. We may totally throw out the community property laws, but it generally deals with what happens in the event of a divorce or death of one of the parties somewhere down the road.
Now, what happens if you don't have a prenup? What is it typically in Arizona? Is it you split everything 50-50? Is there another arrangement?
Arizona first characterizes the property as community property or separate property. Separate property is anything that you own prior to the marriage and anything that you inherit or is gifted to you during the marriage. Community property is anything you earn during the marriage from actual labor. The challenge for most people is that they often want to keep their separate property from being transmuted into community property. And there's a lot of legal concepts and ways that people can unintentionally change their separate property into community property. So a good prenuptial agreement can avoid that unintentional result.
Yeah, and I'm sure it saves people a lot of headaches later in the unfortunate event of a separation and a divorce.
Yeah, absolutely it does. And also sometimes in the case of a messy probate, if one of the parties dies during the marriage.
And that's a really great point. People from different walks of life will decide to get married, and some people have a lot and some people have a little. So maybe you could give us an idea of who is a good candidate for a prenuptial agreement.
I would say anybody getting married for the second or third time who has accumulated some property and may have children by a prior marriage. They are excellent candidates to do a prenuptial agreement because, as I said, sometimes there are messy probates, and the last thing you want is to have your spouse get in a big fight with your children if you die first, or vice versa. You don't want to get into a fight with the other party's children. So people usually going into second marriages bring a lot of property, and they may not wish to commingle it all in the same accounts. The other type of person that really should be considering a prenup is somebody who's getting married maybe for the first time, but later in life after they've accumulated some assets, and again want to preserve or protect those assets from being divided in a divorce. It's even more important if they are self-employed and have their own business, because there are a lot of common law concepts in Arizona that can cause that separate business to be transmuted into some sort of community property. So it's even more important when somebody is a self-employed business person than if they're just a W-2 employee of some other company.
Oh yeah, I mean, that makes a lot of sense because I know when people are younger, they often just have debt. So maybe a college loan or maybe something that their parents gave them to help out. But It's usually not a lot unless they are looking to inherit something or they have a trust set up that they come into at a young age. Um, can you tell us what are some of the most critical assets to protect with a prenuptial agreement?
It's usually the business and the house. What a lot of people don't realize is that, and this again tends to happen in the second marriages or later in life marriages, one party owns the house and the other party moves in with them. And that's fine. And a lot of people think that, well, that house will always be my separate property because I owned it prior to the marriage. But they don't understand that all their earnings after marriage are community property unless they've changed the general rule through a prenuptial agreement. So the community starts to gather a lien against that property. And when or if there's a divorce, they may very well have to pay back some of that money to the spouse that's leaving. So that's the big issue with homes. The same sort of thing applies in businesses, even if the business is maintained as a separate business. If it goes up in value, there is case law in Arizona that will give the new spouse a partial interest in that increase in value. And people have spent hundreds of thousands of dollars figuring out how much that interest is worth in very messy divorces. So the prenuptial agreement can preserve the business as separate without getting into those kinds of issues.
I know. And if you're hiring people to do an assessment on a business, you're right, both sides will have different numbers and they're going to have to try to meet in the middle. And, then you throw in something like a pandemic and you just don't know what's going to happen in the future of a business. So I can see where you're saving them a lot of trouble.
It really is the classic, you can pay me now or pay me later. Having a prenuptial agreement can really reduce the cost of a divorce or a significant probate if people have given some thought to it ahead of time. Frankly, even if you don't end up getting the prenup, anybody getting married should see an attorney and understand how community property law works and how it'll apply to their particular situation. The best time to know that is before you get married, not after you get married.
It's so true.
Yeah.
Well, let me ask you this, and this is just maybe a fun little detail, but when people are coming to you with a prenup, do you find that the couples fight about it? I mean, is it insulting to someone that they get asked to sign a prenup while they're supposed to be marrying the love of their life?
Sometimes it is. Sometimes it's a mutual decision. Usually the later in life marriages where both parties are working already and everybody's going to continue to work and they have kids by a prior marriage. It's more of a business transaction and they understand it a little bit more easily. Often you get cases where the family has assets and the family of one of the spouses is pushing the prenup because they don't want to have to deal with the other spouse if there's a divorce and having to pay them out for a family business interest or something like that. So sometimes the blame gets shifted to it's my parents that want me to do this and not necessarily something that I need to have done. But yeah, there are some people that take offense and that's probably a good discussion to have before you get married and not after you get married. My experience in doing divorce work for 45 years is that the majority of divorces came back to money, not enough of it. One party spends it faster than the other party can make it, and they don't have any agreement about saving, spending, etc. So if nothing else, it certainly triggers those discussions. I can't say I've had a big percentage of people that walked away from the whole thing once the prenup idea was raised to the other party. But there's a small percentage where sometimes that does put an end to the relationship.
I wish when I was younger that someone had explained it to me the way you're explaining it, because I had a home at an early age in my 20s and I didn't know that I should do that. And so, you're young and in love and you don't realize that this is one of the biggest financial decisions that you can make, to tie yourself to somebody else. And a lot of times you don't even know if they have bad credit or not. And you could be tying yourself to someone else who has a lot of debt that you are now partially responsible for. And, possibly you could lose everything. And it's very sad. I actually know someone that happened to. She's very responsible, and the guy just had a gambling problem and he stole her grandmother's jewelry that she had inherited. And she ended up going bankrupt trying to keep up with all the bills that he left behind. And I know somebody else that his family took him out of the will because he married the wrong person and the divorce was taken forever. And they just wanted to make sure they didn't lose their multi-million-dollar business to this woman that they were married for less than a year. I mean, so there are so many things that you can't foresee. This is just like an insurance policy.
It really is. One of the requirements in Arizona for an agreement to be enforceable is that both parties have to make full disclosure of all their assets and liabilities. So think of it as almost applying for a bank loan. You fill out a list of everything that you own and what it's worth. When I do them, I even go a step further and ask the parties to exchange 3 years of income tax returns so that no one can come back later and say, well, gee, if I had known that was your income, I would have negotiated this differently. Again, you have to have a high level of transparency going into the marriage in order to have a valid prenup. So it's a worthwhile exercise, because you're right. There's folks out there that are not playing, or they're playing a little fast and loose, maybe is what I should say, and they're not revealing the debts they're bringing or the liabilities and so forth. So a prenup protects both parties in that regard, because they're each disclosing to one another what their assets and liabilities are.
It's almost like you're really showing true love if you can be mature enough to sign one of these prenups. And honestly, the way you describe it, it sounds a lot like a divorce, but in the beginning. And you have to trade numbers, and some people are super surprised at the end of their marriage about the assets that they have. And sometimes they're surprised about the debt. So yeah, I'd rather know ahead of time.
Absolutely. It's should be a requirement anyway. The legislature is always looking for ways to reduce the divorce rate. And frankly, I think if they required full disclosure before they issue you a marriage license, we'd probably eliminate a lot of unhappy marriages right at the beginning before they ever occurred.
Yeah, that along with background checks. So can you tell me, are these prenuptial agreements actually enforceable?
They absolutely are. Again, if you jump through all the appropriate hoops, the courts are very much in favor of negotiated settlements and avoiding litigation if they can. And so if the agreement is in writing and it's signed, and it has to be signed before the marriage, and you've made full disclosure of the assets and liabilities, Arizona says that they will enforce the agreement unless it is unconscionable. So whatever agreement you've made would have to literally shock the conscience before the court would even consider throwing it out. Now, along with that, there's a body of case law that talks about not using undue influence or pressure or forcing somebody to sign. So, of course, the classic example is the Friday night before the Saturday wedding, the husband brings the wife down to his attorney's office and says, here's the agreement, sign it, don't even bother reading it, don't take it to an attorney. Well, those kinds of agreements aren't going to be enforceable. The law very clearly makes allowances for anybody that's been forced into signing a document at the last minute. So we always recommend that both parties have their own independent legal counsel and that they try to start this process early enough that everybody has adequate time to review the documentation and then sign it well before the marriage when they're not under pressure.
I mean, that makes sense. I would never want to sign any legal document without having my own attorney look it over. And, this is certainly one of the most important times to do that when you're about to enter into a giant financial contract, basically. And who knows what'll happen? Who knows how long it'll last? Maybe it'll last forever and none of it matters. But, what's the harm in having a little bit of insurance? So can you tell us, I know you mentioned a couple of the documents earlier, what type of information should they provide to get a prenuptial agreement?
When they come to the attorney, we don't need, we do take their word for it. So if they say they have a house and it's worth about 150,000, that's all they need. They don't need to have an independent appraisal. They don't need to bring in a mortgage or any of that documentation. But they do need to prepare a list identifying the specific assets and what they think they're worth. We usually put language in the agreement that says all of these are good faith estimates. They could be off by a little. I mean, it's easy to estimate the value of your bank account or your stock account because you can look it up on the internet every day. But the value of your home fluctuates. The value of your business may fluctuate. So you're given a little leeway there to put a fair market value on those kinds of assets. And that's really sufficient. So that's really all the client needs to put together is this list of assets and liabilities. And as I say, some people would use maybe a bank mortgage application as a format to make sure that they've remembered every little asset from CDs to IRAs to 401ks to houses and businesses.
I mean, and that makes a lot of sense. Sounds like it's a thorough process, and there's certainly quick fixes for figuring out what your real estate might be worth. I mean, gosh, nowadays though, you might have something on Zillow, a number on Zillow, but then there's so little inventory out there. People are paying crazy amounts over the asking price, and there's a lot of bidding wars right now. So, I mean, it might be a good idea to do something a little more concrete, but at least you're getting something down on paper and some sort of idea.
Exactly. And it really, I have advised many clients that they may want to save some of their documentation from right prior to the marriage if they ever need to prove how much was in the 401k prior to the marriage or the IRA account. So sometimes there is advice given to preserve some documentation to be able to prove what these assets were worth in case somebody challenges it later.
So you were saying that there really needs to be plenty of time for both parties to look over these prenuptial agreements, have their attorneys look it over and make adjustments when needed. How much time do you think is necessary to really get this process done thoroughly and correctly before the marriage?
Ideally, you would like to sign the prenuptial agreement at least 30 days prior to the marriage. Now, that's not to say I just signed one today and they're getting married on Saturday. Today is Thursday as we're speaking. And this was a rather rushed negotiation, but both parties had attorneys and both parties fully understood what they were signing. And I negotiated a lot of changes to the first proposal made by the higher earning spouse to the lower earning spouse who I was representing. So I do think it's fair, but in the ideal situation, you'd like to get all that done maybe a month before the marriage, because who wants to worry about running around to sign a prenup 10 days before the marriage when they're worrying about the caterers and the DJ and everybody else for the wedding. So if you want to do that, I would back it up another 45 days and say you really should start this process maybe 2.5 to 3 months before the wedding date. And that should give both sides adequate time to find an attorney and review the documents and negotiate any changes, and then get it signed and still have plenty of time. Every prenuptial agreement says that if for some reason the marriage does not occur, it's not a binding document. It only becomes effective upon the actual marriage of the parties. So there's no danger of signing something and then for some reason the wedding doesn't occur, and it's not a binding document on them. It only becomes effective on the actual occurrence of a wedding ceremony. One situation I get sometimes, and it's usually when I'm representing the party who is the wealthier party that's trying to preserve their assets just to make sure that they're not unwittingly dividing things up. The other spouse is willing to sign almost anything and they don't even want to get an attorney. And in those situations, I have to explain to my client that he or she may want to actually pay for the other attorney, because that attorney is their insurance policy, that the other party won't come back and say, gee, I don't know what I signed. I have no clue what I'm doing here, and then try to throw themselves on the mercy of the court and have the agreement declared unenforceable. So again, the sooner you start down that road, the more time you have to convince people, no, you really do need an attorney, and if necessary, I'll pay for it, but both sides should be represented, and we need time to fully negotiate out all the specific terms.
That makes a lot of sense. And like we've talked about, there are a lot of surprises, especially when you start digging through the numbers. So you want to have plenty of time to sift through that and deal with whatever surprises come your way, so that you are properly protected and that the negotiations are true, because you can't negotiate if you don't have the real numbers. The same thing at the end of the divorce.
Exactly. And one common thing that comes up is the one party is moving into the other party's house. And that's all well and fine, but what happens if there's a divorce filed and the party that moved into the other party's home, how long do they get to stay? Can they be kicked out on a moment's notice just because a divorce is filed? So how do we negotiate how long they're going to be able to continue at the home of the other spouse? Or if there's a death, and let's say husband wants to leave the house to his children, well, how long does ex-wife get to stay in the house? Or maybe she gets to stay until she decides to move or until she dies. And if so, who pays the mortgage payment during that time and who pays the utilities? So as you can see, there's a lot of different moving parts that can be negotiated between the parties, even on that one little issue. So, multiply that and you see why we need the extra time to really sit and talk.
I mean, it sounds like there's a little bit of estate planning going on with all of this discussion.
Actually, there is. There's a number of estate planners who do prenuptial agreements, although a lot of them don't have any background in family law, so they don't know what happens in a divorce. And so I'm not sure if their background is quite as good, but very definitely there are some aspects of estate planning. And sometimes we put provisions in the prenuptial agreement that will require changes to a party's trust or will after the date of the marriage. So that's a point in negotiation sometimes. If I die, I will make sure that you have X number of dollars. Or sometimes we negotiate insurance. That's the way around it. Okay, I'm not going to name you in my will, but I'll carry a life insurance policy in the amount of X dollars as long as we're married, so that you won't be left high and dry if I pass away.
I mean, and that is good. And it's so hard to think about all of those moving parts. And this is where I'll mention one of the amazing things about Stewart Law Group is that you handle both estate planning and family law. So you have that expertise, and there's just decades and decades of experience and strategy behind any attorney that works with you at Stewart Law Group. So if anyone out there has any questions themselves or someone they know that might be about to get married, they should definitely give the Stewart Law Group a call, because I can guarantee you that sitting down with someone and talking about the situation and asking a few questions, getting a bit of information is going to open up your eyes to a whole new world of things that you should be doing before you get married to make sure that you're protected.
Absolutely. I have a case right now, a former client who I have done a prenup for before, and I'm not quite sure how that marriage ended, but before he wanted to do the prenup, he came to us and revised his estate plan. So we're now waiting on getting the prenup to be done, but it is a lot of crossover. Our estate planner often sends me cases and vice versa, because the two areas do overlap.
Well, your clients are lucky to have you, and I really appreciate your sitting down with us today, Robert. It's really great to meet you, first of all, and I do hope you'll come back and speak with us again someday soon.
I'd be happy to do that anytime. Thank you.
You are so welcome, and thank you. And thanks to everyone who's listening today. We will look forward to seeing you soon, and I hope everyone has a great afternoon.